Sure, the GDPR can be summarized in three main points. The first thing is that privacy becomes a risk-based approach, so no one will tell you anymore what kind of security measures or technical measures you have to implement. Therefore, data controller and data processor will become accountable for the decision they take and the security measure they implement. The second provision, which is relevant according to the GDPR, are sanctions. Sanctions are increased up to the 20 million or up to the 4% of the total worldwide turnover of the preceding financial year. Therefore, data controllers and data processors may face huge sanctions. The third new provision regards class actions. Other than before, data controllers and data processor might be brought before the supervisory authorities for the infringement of data protection law. The fourth thing, which is the most relevant and relates to the new rights introduced by the GDPR, and which I can summarize in the principle of accountability. So data controllers and data processor will be accountable for any decision and any technical and organizational measure that they will implement within their own organization. Therefore, they will have to take a data protection by design and by default approach. They might be required to take data protection impact assessment. They might be obliged to appoint a data protection officer, and more in general, they will be accountable for any decision they take regarding the data processing. Yes, what I suggest in my position paper is that the new proposal for a general data protection legal framework in Brazil represents a good effort because it resembles the European Directive 95/46. What I suggested is to the Brazilian representative, to those congressmen and congresswomen who are actually discussing this law, to take a step further and implement those rights who are implemented in the GDPR, like data portability, data protection by design, and by default. Today I had the occasion to face and to discuss this matter with the Brazilian representatives, and it looks like next week or probably in 2 weeks the proposed text will come to the final text, so we will see how it is aligned with the European data protection law. Well, there is not one single point that I would highlight. The white paper represents a summary of the outcomes of the clustered projects regarding the free flow of data, the ownership of data, and the access to data. So it may serve to international stakeholders as a reference to all technologies, prototypes, methodologies, and outcomes that have been made by the projects who or that project are actually and currently developing. So I will not suggest one single point that I would like to highlight, but it may serve as a global document, 110-page document that may serve as an outstanding tool for all the international stakeholders who wants to deal with the free flow of data.